Members, good morning. This is the regular meeting of the panel on Manpower. We have a quorum and it's the appointed time. I call to order the meeting. Agenda item 1, information papers issued since the last meeting. Since the last meeting, the Secretariat issued to members 1 information paper. The detail is set out on the agenda for members' reference. Agenda item 2. One of our discussion items today, measures to foster harmonious labor relations by the Labor Department. I will first invite the government representatives in charge of this to enter into the meeting room. Welcome. With us today we have Mr. Raymond Ho, Deputy Commissioner for Labor, Mr. Raymond Liang, Assistant Commissioner for Labor, and Mr. Ma Kwok Koon, Chief Labor Officer. Welcome. Members who'd like to speak, please press the Request to Speak button. I will first invite Mr. Raymond Ho, Deputy Commissioner for Labor, to walk us through the paper. Over to you, Deputy Commissioner. Good morning, everyone. For this discussion item, we will first talk about the measures undertaken by the Labor Department to foster harmonious labor relations. The Labor Department has been adopting a multi-pronged strategy for maintaining and fostering harmonious labor relations. In terms of preventive measures, through various channels, we provide consultative services to help employers and employees understand the employment to reduce labor disputes. On early intervention, officers from the Labor Department on a day-to-day basis keep in close communication with labor unions and organizations as well as employers to deal with any potential disputes or relevant intelligence so that we can intervene early to help resolve any labor disputes. When labor disputes occur, the LD would provide a conciliation service. We hope to adopt an approach that takes into account legality, reasonableness, and compassion to help deal with labor disputes. According to the paper, we see that there have been more labor disputes as well as employment claims in the catering sector as well as the construction industry. We have been liaising with relevant stakeholders in the construction industry, including the principal, contractors, subcontractors, as well as relevant labor reunions. We have been closely monitoring the different works projects as well as the payment distribution to workers. If there are any default payment, we will ask the employers to immediately disburse the payment. If the employer is unable to pay the wages in arrears, we will ask the employers to provide the relevant records on default payment so that the principal contractor will take up the responsibility under the employment ordinance. For the catering industry, we have had some closures of restaurants. We ask employers to comply with the employment ordinance to pay any wages in arrears. If they determine to terminate the contract with their staff, if again, the employers are unwilling to pay the wages in arrears, we ask them to calculate the payment in default as well as compile relevant records. We also ask them to sign the declaration to show that they are unable to pay the wages in arrears so that the workers affected will be able to apply for ex gratia payments from the Protection of Wages on Insolvency Fund. We will continue to keep in close communication with employers and employees. We hope that through prevention and early intervention and the provision of consultation service, we will be able to foster harmonious relations between employers and employees. Thank you, Deputy Commissioner. 5 members have asked to speak. I'll read out the lineup. First, Mr. Chao Xiu-chung, followed by Ms. Lillian Kwok, Mr. Shanghai Long, Dr. Frankie An, Deputy Chair, and myself. I will give each member 4 minutes, including questions and answers for the first round. Mr. Chao Xiu-chung, please. Paragraphs 4 and 5 of the paper mention that the Labour Department would, through multi-pronged approach, foster the implementation of family-friendly employment practices, but this has not been very effective. For example, the Labour Department asks employers to follow the employment ordinance to offer paternity and maternity leave, but according to information last year, less than 1% of non-government organization workers enjoy the entitlement to such leaves over the statutory level. The number of maternity leaves in Hong Kong is lower than that of other neighboring places and countries. While the government encourages childbearing, does the government have any plans to, in a gradual manner, increase the number of maternity leave or childcare leaves for employees? That's my first question. Second, people work for long hours in Hong Kong. There have been people who are suspected of dying of overexertion in Hong Kong. We want the government to give a definition for overexertion, for example, based on the number of working hours. Can you come up with guidelines to ask employers not to ask their employees to work for working hours that's too long? Also, on the tripartite mechanism, there was a guideline for 11 industries. Is the government going to continue to work with the tripartite committees to come up with the standard working hours? Also, according to the government, the number of labor disputes are on the rise. I want to know if the Labor Relations Division has enough manpower. We see 13% of vacant positions at the Labor Relations Division, and that's an increase compared to previous years. So you have the establishment, but you haven't been able to fill the headcount. We need LRD to step up inspections against irregularities. Will you be able to deploy manpower from other divisions or other departments so that we can have more inspection officers to help strengthen inspections? Deputy Commissioner, I thank Mr. Chow for the questions. On paternity and maternity leave, earlier the government completed a review and increased the number of maternity leaves from 10 to 14 weeks, and for paternity leave we increased the number of days from 3 to 5, and we have already implemented the new arrangement. We will continue to monitor the situation. We have to take into account the socio-economic condition. We also have to consider the various views of employers and employees and relevant stakeholders. Where appropriate, we will conduct a review again. On working hours, Mr. Chow raised 2 questions. For industry-specific guidelines, we worked very hard to liaise with employers' association as well as labor unions. We had a discussion on the core issues, for example, the standard working hours as well as compensation for overtime work. There have been divergent views, and it's not easy for each of these parties to reach a consensus. we will continue to work to formulate a guideline for different industries. If we have any thought, we will report it to this panel. On death from overwork, a number of years ago, the government commissioned the OSH Council to conduct a study. As we all know, this kind of cases can be caused by a number of reasons. We cannot simply attribute the reasons to, for example, overtime work or a certain factor. On occupational disease or preventive measures, our department will look at how we can prevent death from overwork, and we will strengthen our work in this regard. Mr. Chow is concerned about the manpower situation of the Labor Relations Division. There has been staff wastage, and every year we hold recruitment exercise. Recently, there's a new batch of recruited inspection officers to help fill the manpower gap. Every year, we manage to meet the target set in terms of the number of inspections. We need strategies, and we adopt a risk-based approach as we conduct inspections. We mainly look at whether there are any industries or enterprises that are subject to higher risks. If we receive any complaints, we would conduct inspections immediately to ensure effective law enforcement. Next, Ms. Lillian Kwok. I think employers and employees should align with each other in terms of their vision for the companies. They should both want the company to be able to make money. If the employer fails to make profit, employees will lose their jobs. So today we're here to discuss how we can improve labor relations. A lot of times, disputes arise because of unclear contract terms. Disputes arise when employers and employees cannot agree on how the leave should be calculated and how their pay should be calculated. Should it be a paid leave or no paid leave? How should holidays be calculated? Can compensation be given if the employee works overtime? There are always misunderstandings on these issues. A lot of SMEs, they do not necessarily know how to draft contracts. Can the Labor Department go one step ahead to offer assistance to employers of SMEs? They may not be able to afford to engage a lawyer to go over the documents for them. Say I am an employee and I notice something weird in my contract. Can I consult the Labor Department by bringing my contract to them? I think there needs to be a standard form of contracts to prevent labor disputes. Second, on data. You've included statistics on labor disputes in your paper. For industries such as the construction sector, the catering sector, as well as administration sector, have you done a studies on how many labor disputes each industry has? But do you know how many people are working in these industries? For transport and logistics sector, there might be fewer workers, and the number of disputes over the number of workers working in the industry may be different. some SMEs may require more support, but we cannot tell which SMEs require more support from your statistics. I used to work 60 to 70 hours a week. Now I work even longer each week. On standard working hours, it's hard for us to come up with the standard. This is because each industry is different. For the show business, a lot of the workers don't get to take day off. However, for low seasons, they may have 2 months of leave. Do you have any statistics of the daily average working hours for each industry? I think it's easier for us to come up with standard working hours for office workers. I suggest that you carry out a study in this area first.
Deputy Commissioner, I thank Ms. Kwok for her suggestions and comments. Regarding her first comment on publicity and consultation, we agree with what you said. We will continue to make use of different channels to promote various provisions in the employment ordinance. We do have guidelines and leaflets to facilitate understanding of the regulations of employers and employees. We also have standard contract for reference. We also offer consultation services for employers and employees. On the point about data and figures, we collect claims and a number of disputes according to actual figures. I think that the figures that we have are of value. Construction sector, the catering industry are sectors where there are many cases of wage default and disputes. And that's how we target our measures. However, we will still look into whether there is any room for us to improve our presentation of data. Third, on standard working hours. That's a very controversial subject. The administration has no plan to legislate for standard working hours. We don't think that is the right way to go. We tend to resort to publicity and education to encourage employers to adopt family-friendly practices. Thank you. Ms. Kwok? We all are here to solve problems. We want to facilitate a harmonious society. So I hope that you will establish a department or division that offer consultation services for contracts or agreements. Second, I think that you should provide a reference on standard working hours for different industries, just like what you have for contracts and agreements. Thank you. Next, Mr. Zhang Hailong. Thank you, Chairman. We all want to foster harmonious labor relations. Members of the HR department play a very crucial role in this. They have the responsibilities to fully understand the rights and obligations that employees have under the employment ordinance. I've received about 100 inquiries from imported workers that come via different labor importation schemes. HR workers of SMEs may not be familiar with contract agreements. Sometimes immigration department may grant 2 to 3 years of stay for imported workers, and they are allowed to work with no fixed hours. But sometimes the HR workers are not aware of the conditions, and sometimes there's misunderstanding and confusion. However, I don't see the Labor Department educating the HR sector on the conditions of stay of imported workers. I wonder if the Labor Department has any plan to promote it. Thank you. I thank Mr. Shang for his suggestion. It's the first time that I hear that this problem exists. There could be no end date to a contract of an imported workers or anyone coming via the Top Talent Pass scheme. The end date of the contract may not be the same as the end date of the visa. There is no necessary correlation between the two. I will ask my colleagues to step up publicity and education. Thank you. Mr. Shang? Because well over 100 of such cases have happened. The HR department are afraid of breaking the law, and that's why they usually don't grant a contract that is longer than the period of the visa. So I hope that the Labor Department will educate the HR departments of Hong Kong. All right, I hope that the Labor Department will look into it. Next, Mr. Ngam and you, Deputy Chairman. Thank you, Chairman. I have 3 questions. First, the Deputy Commissioner for Labor said just now that they are adopting family-friendly practices in the administration. And I wonder if the Labor Department has any data collected from the Civil Service Bureau so that we know more about what kind of a family-friendly practice have been adopted. We want SMEs to offer compassionate leave, childcare leaves to their workers. Very often, the CSB make reference to the practices in the private sector. But I think that it's time now for us to summarize the family practices that we have within the government so that the private sector can learn from the administration. And I see that the conciliation service has been very effective. The number of cases solved with the service has exceeded 70% for years. Have the administration looked into the reason why some complainants or employers don't want to engage in conciliation services? So I wonder why the remaining 20 to 30% of people not participating in the service. And I wonder if the Labor Department will make use of AI to facilitate their work. Deputy Commissioner. I thank Mr. Ngan for his 3 questions. The Civil Service Bureau has been adopting family-friendly practices. We've been in close liaison with them and we exchange views quite regularly. The CSB has launched new measures, say for example, compassionate leaves, has been offered to our employees. Overall speaking, if we talk about private markets, we're talking about many different industries. Different sectors may have their own considerations, but I think that they can learn from the government nonetheless. Now, your other questions on artificial intelligence. We have to dovetail with the overall policy of the government. For clerical related works, I know that Policy Bureau's been launching AI systems. We are trying to also enhance IT support for our colleagues. Regarding conciliation service, well, I will ask Mr. Ma, Chief Labor Officer, to elaborate. Thank you. Mr. Ma. Mr. Ngan. As mentioned in the paper, the percentage of cases resolved with conciliation services has consistently exceeded 70% for years. As for the remainder of the cases, many have gone through conciliation, but some of them may not be successful. The reason why they fail is because there could be disputes regarding facts of what happened among different parties, and sometimes they have to seek adjudication from courts. For some other cases, legal disputes may be involved. Sometimes we were not clear about who the employers were. For some other cases, one of the parties may have already disappeared, and that's why the cases could not be resolved with conciliation services. Mr. Ngan, I wonder how many of the cases did not go through conciliation. Well, it's hard to say. We often engage different parties in a meeting, but sometimes we provide conciliation services on the phone or in other forms. As long as one of the parties respond to our offer, we try to provide them with conciliation service. Thank you. Next, Mr. Shiokafai. Thank you. We're here to discuss measures to foster harmonious labor relations by the Labor Department. Now we are going from stability to prosperity. Without the opposition camps here in the Legislative Council, we see that these societies become more harmonious. These days, we've been focusing on disputes between employers and employees. We have 3 million employees in Hong Kong, and in 2024, there were only 89 cases of labor disputes, and from January to September 2025, we only have 99 cases of labor disputes. We have so few cases of labor disputes. How come the relations between the employers and employees is still so tense? So I think that we should not exaggerate things. The business sectors value their employees. That I'm sure. Otherwise, our society wouldn't be able to function. Even if sometimes employees file claims, it doesn't mean that they have bad relationships with their employers. Out of 10,000 cases, 90% were able to be resolved via conciliation services. Disputes over claim may happen because of some information missing out from the contract. So as long as we state very clearly the job scope, the period of employment, and other important information on the contract, then a lot of disputes can be resolved. I'd like to raise a point. Over the past few years, Hong Kong is infamous for poor service attitude. What is the reason behind that? Is it because we don't have enough workers and therefore the remaining employees overworked, and as a result their working or service attitude is poor? In 2023, when Xia Baolong met with the administration, he warned us that we don't have enough workforce. And immediately after that, we imported workers. We have an aging population. We have the lowest fertility rate. If we don't import workers, it's difficult for us to solve the problems that we have at hand. We don't want what's going on in Japan happen here. We don't want a recession for 30 years. For sectors that have a high unemployment rate, then we have to adjust the ratio. But we should not demonize imported workers just to protect the local workers for the sake of it. I don't think that suspending labor importation scheme is the way to go. And I think that we should be pragmatic. We should tell stories using facts and figures, and we should not exaggerate the disputes that we have. We have 3 million employees, and we have only less than 100 cases of disputes.
Deputy Commissioner, I thank Mr. Xu for the comments. We agree that we are doing quite well in terms of labor relations in Hong Kong. Of course, we can't be complacent. We have to continue to work hard to foster harmonious labor relations. On resolving labor issues, we stress a tripartite approach involving employers, employees, and the government. There might be different views from different parties, but I agree that we need a rational discussion to reach a consensus. For a lot of labor issues, through honesty and communication, we managed to find a suitable solution. We hope that we will continue to stick to the tripartite approach and that we can promote the socio-economic development in Hong Kong together. Next, Mr. Lai Tong Kwok. 2 questions. Just now, Mr. Peter Xu said we do not have many labor disputes each year. My guess is that you offer conciliation service to those who face labor disputes. Say an employee is fired by his boss, and the employee goes to the labor tribunal to seek adjudication. And before he does that, you intervene. So I understand that your workload is heavy. If you fail to help employers and employees reach a settlement, the employee would go to the labor tribunal. Oftentimes, employees have to wait for a long time for their case to be handled by the tribunal because of the heavy caseload. An employee who loses the case may have to pay for the costs. While both parties will not be allowed to engage a lawyer, for the party that wins, he may ask for costs. And so people struggle whether they should go to the labor tribunal for help. In this regard, does the Labor Department have any thoughts? Second, the administration just now said if a company has to be folded, and if employees recover compensation or statutory compensation, then the employer will have to prove that he cannot make or settle the payments. Say the employer refuses to sign this declaration. Would that hold employees up for recovering the compensation payment? Will the employees have to go through a much longer procedure and wait for the company to be liquidated in order to get the compensation payment? In this regard, do you think you can help employees affected get the statutory compensation payment under the law as early as possible? Deputy Commissioner, I thank Mr. Lai for the questions. On the mechanism to deal with labor disputes, over the years, we see a high percentage where we manage to help employers and employees reach a settlement. 77% of the cases see such a success. My view is that, as the conciliator, we would give an objective analysis for both employers and employees. If both parties are willing to engage in a rational discussion, in the majority of the times, they manage to settle the disputes. For some cases, even after they get our conciliation service, they stick to their own positions. The conciliation service we offer is voluntary. If both parties stick to their own positions, and if they have to go to the labor tribunal to seek adjudication, well, it is a rather simple and straightforward judicial procedure to help employers and employees deal with any disputes. As to whether costs would have to be paid by any of the parties, well, not just the employees. If the adjudicator thinks that the employers unreasonably refuses to settle the compensation payment, then the employer would have to pay the costs. So I think this is really up to the educator, and on a case-by-case basis, adjudicators would decide which party should pay the costs. On company closure, if it is confirmed that the employer is unable to settle the payments owed to his employees, then we will ask the employer to sign the declaration, which is the statement of inability to pay. Some companies may have to apply to the court to be liquidated and have to go through the bankruptcy procedure. And there needs to be sufficient documents to prove that the company is eligible to file for a bankruptcy petition. In some cases, we explain to employers about the situation. If the employer is really unable to settle the payments owed to his employees, then we ask them to compile the relevant records. And if they agree to sign the declaration, then his employees would be able to apply for ex gratia payments from the Protection of Wages on Insolvency Fund. For the majority of the cases, employers are cooperative, and most of them were willing to sign the statement of inability to pay. We will review the entire procedure to see how we can improve the entire process. So we will continue to keep in view the procedure in this regard to see how we can further make improvements. Thank you. Next, Mr. Kwok Wai-keung. I thank the Labour Department for its hard work. The FTU reported to the administration about unreasonable deduction of leave during typhoon. I want to know how many such cases has the department dealt with. Also, during inclement weather, did you receive any cases about on-duty allowance? Now, paragraphs 5 and 6 mention that there is this tripartite consultative mechanism. And Human Resources Managers Club were established for different industries. And according to the paper, there is a tripartite mechanism for different industries, including construction industry, theater, logistics, property management, hotel, tourism, and so on. Have you come across any issues? I want to know what kind of topics have been discussed under the tripartite mechanism. Now, on the Good Employers Charter scheme, I understand that employers take part in this on a voluntary basis. Apart from asking employers to sign up for this voluntarily, would you proactively reach out to employers to join the charter instead of sitting here to wait? If you just sit here and wait, you won't see a lot of participants. Well, this is not a reward for employers. So I hope that for employers who perform well, you would invite them to join the Good Employer Charter. In the long run, of course, we want greater protection for employees. That's a more practical approach. Deputy Commissioner, I thank Mr. Kwok for the comments. During inclement or extreme weather in relation to the work arrangement, we stress the following. First, employers would have to prepare in advance. They have to talk to the employees and reach an agreement on the work arrangement, which must comply with the law as well as the contract terms. As for individual cases, I'll ask my colleague to share the details with you. Now, for the tripartite mechanism. Tripartite meetings are held regularly for different industries, and there are regular discussions from different industries on topics that are of people's concerns. Mr. Kwok is very familiar with this for digital platform workers. At the moment, we have to come up with a framework for giving delivery workers the compensation in case of work injuries. Now, for the Good Employer Charter, we're going to roll out the new edition in the next quarter, and we'll definitely invite employers to join the charter. On individual cases we dealt with, I'll ask Mr. Ma to tell you more.
一啲即係比較
Thank you. Let me first go over some more general cases. I thank Mr. Kwok for his concern regarding a work arrangement in inclement and extreme weather conditions. We often stress that the employers and employees should agree on work arrangements before any inclement or extreme weather conditions happen. They should work out arrangements regarding the pay, the number of working hours, etc. Employers have to ensure the safety of employees. If employees were not able to make it to work during extreme weather conditions, we ask the employers to be compassionate. As we processed these cases, we noticed a number of points of concerns of employees. First, it has to do with pay. If, say, statutory annual leave's been deducted from the employees to make up for the absence of employees due to inclement weather. Second, pay of employees. If they cannot make it to work during extreme weather conditions, will their pay be deducted? And if they are asked to work during those conditions, will they be enjoying additional pay? If we take the Regatta Super Typhoon Day in September as an example, we have compiled statistics. After typhoon, we received 130 inquiries. We're still collecting information on it. These 130 inquiries are about the two areas that I just mentioned. After explaining the statutory requirements to employers and employees, we have not received any claims from employees after the typhoon. After listening to our answer, maybe the employees have sorted things out with their employers. That's why we've not received any claims. We're not sure about the situation. If the trade unions received any complaints, they may refer them to us. The Deputy Commissioner for Labor just explained the tripartite consultative mechanism. We do organize regular meetings. We invite business associations, trade unions to attend the meetings of the tripartite committees. We discussed issues relating to labor demand, labor relations, so on and so forth. If you come across cases that are not under the purview of the tripartite committees, we refer them to the relevant policy bureaus. Lastly, on good employer charter, I thank Mr. Kwok for his support. I know that he wants us to improve the charter. In 2024, we launched the Good Employer Charter. The number of signatories have significantly increased since then. As we launch the new round of Good Employee or Good Employer Charter, we want to take things to another level. We may proactively invite good employers to join the campaign or charter. Thank you. Mr. Kwok? In the logistics industry, there is a successful case where the disputes were resolved through conciliation services. There are still outstanding cases that need to be processed. I call on the employees to speak up for themselves. If they don't want to file their case today, please keep your records properly, just in case. Mr. Lam Chen-sing, thank you. Wage default hurts labor relations. All employees want is to get paid. According to the government statistics, labor disputes lasting over 20 days and cases of wage defaults been going up. If we compare 2024 and 22, there's an increase of 50% in terms of the number of labor disputes and claims handled. There is also a 20% increase in terms of the number of cases of labor disputes in the first 9 months this year. It could be because of our economic transition. I appreciate that the Labor Department has been initiating more prosecutions. Previously, they only prosecute 15% of the cases. Now the figure's gone up to 1/4. We know that the court enjoys judicial independence, but judges tend to be overly compassionate towards the employees, or rather employers, and they often fine them just $1,000, while littering will attract a fine of $3,000. So I wonder what the Labor Department's view is on the fine handed down by the court and what measures they have to promote the criminalization of wage default of employers as we see the figures going up. And I know that the Labor Department is launching a good employee recognition campaign. Over 1,600 organizations were accredited as signatories to the Good Employer Charter. And I wonder how many employers joined the upgraded version. And I wonder how regular the meetings of the tripartite committees is. How often do you organize meetings? Do you convene meetings once every 3 months, for example? I think that the baseline is that we have one meetings every 3 months. Thank you. Deputy Commissioner, thank you. I will address the question on wage arrears, and then I will ask the Assistant Commissioner to elaborate. Thank you. I completely agree with what Mr. Look said. Getting paid is a basic right of an employee. We do not accept wage default or arrears in any form or way. As always, we will take enforcement action stringently. When there's enough evidence, we initiate prosecution. So as you can see, the number of convictions is on the rise. Regarding the fine level of the court, or the fine handed down by the court, I believe that the judges look at the amount of wage in arrears, the length of time the wage been defaulted before handing down the fine level. Our colleagues offer the court with relevant information. There were cases in the past years where employers were sentenced to social or community service. And when employers still fail to pay wages to employees despite being convicted at the labor tribunal, the court handed down even more serious sentence. Some employers were jailed. I agree with what Mr. Look said. We will step up publicity and promotion to highlight the seriousness and the consequences of wage default. As for the other two questions, I will ask the Assistant Commissioner to elaborate. Thank you. Thank you, Mr. Look, for the question. The supportive, family-friendly, good employers, about 1,002 organizations were accredited as awardees. So that account for 2/3 of the 1,600 organizations that are accredited as signatories of Good Employer Charter. In 2026, we want to also give awards to employers that adopt family-friendly practices in their workplace. As for the tripartite committees, well, we organize together with them activities and events. As to how many activities are being organized, we invite members from the tripartite committees to our events 3 to 4 times a year at least. And within 1 year, we have at least one meeting with the tripartite committees. As mentioned, we invite a trade union, business associations representatives to these meetings, where we discuss employment, labor demand, labor relations, legislative amendments, so on and so forth. Thank you. Some frontline workers may participate in these meetings on behalf of their trade unions, but most of the time these meetings are organized during work days and working hours. It's difficult for them to take leave, and not every employers are as understanding. If you organize just 1 to 2 meetings every year, it's difficult for employees or trade union representatives to take leave from work to join it. I call on the employers to be more understanding of their employees who need to attend these tripartite committee meetings. Thank you.
Lastly, it's my turn. This topic is about harmonious labor relations. In the past, we simply look at whether there is an employment contract when we define whether there is a labor relation. If there is such a contract, you can ask for compensation at the Labor Department. Without the contract, you'll not be able to get your entitlement. Say, for example, platform delivery workers. They do not enter into employment contracts with employers. In the past, the Labor Department could disregard such cases if you do not have an employment contract. In the past, labor disputes arise when there is, say, a commercial contract, and you can, through civil litigations, recover costs from the small claims tribunal. But nowadays, this no longer applies. The Labor Department may well be aware of the change, and in recent years the Labor Department has done a lot more for a delivery worker who is not officially an employee and has not entered into an employment contract. Even for these cases, the Labor Department works hard to follow up on these cases. Even a tripartite committee was set up by the department to see what kind of policy measures could benefit these delivery workers. It is also announced in the latest policy address that delivery workers could perhaps enjoy compensation in case there are work injuries. I appreciate this. With the development of gig economy, there could be more and more such cases. These cases may not only concern platform delivery workers. If the bill concerning ride-hailing services is passed tomorrow, perhaps in future, drivers that offer ride-hailing services may go to the Labor Department for help. They might concern the orders they take online, and also there might be work injuries. So I think we need a broader definition for labor relations. Take delivery workers as an example. They might not be an employee, they might not have signed an employment contract, but they could be considered as employees as well. And there will be more and more such job types in the future. What kind of strategies does the Labor Department have to tackle this? You might need more resources and manpower in case there are labor disputes in future that involve such workers. Deputy Commissioner, I thank Chairman for your questions. The Labor Relations Division of our department moves with the times. Regardless of your job type, if you come to the Labor Relations Division, we would offer the relevant assistance and support to you. Even if you are a self-employed worker, as long as you have a job and you come to our office, we would provide you with our services. We have stepped up our consultation service. We offer special consultation services for example, imported workers and platform delivery workers. We learn from them their job patterns, and we tell them our analysis and our suggestions. For self-employed workers, the situation might be different, but it will be the platform delivery workers that will face the biggest challenges in future, because this is a new job type. So as the chairman said, we'll have to think about how to help them. In the latest policy address, the chief executive announced that we will first deal with compensation for delivery workers that injured at work. As for the amount that employees should get for each piece of their work, we will deal with this later. We are currently looking at the compensation for those who get injured at work. As for the other issues, we will make use of the tripartite platform. We will deal with these issues through negotiations to handle issues of people's concerns. Thank you. So we have wrapped up this item. I hope the Labour Department have heard members' views and that it would work with us to foster harmonious labour relations. Thank you. Now we move on to the next discussion item. It's also agenda item 3 of today's meeting, regulation of employment agencies. I'll first invite the government representatives to join us. With us, we continue to have Mr. Raymond Ho, Deputy Commissioner for Labour, Mr. Ronald Choi, Acting Assistant Commissioner for Labour, and Ms. Ruby Chu, Senior Labour Officer. Welcome. Members who'd like to speak, please press the Request to Speak button. I'll allow time for the Deputy Commissioner to walk us through the paper. Deputy Commissioner, please. Thank you, Chairman. I will first brief members on our work to regulate employment agencies. We are responsible for enforcing Part 12 of the Employment Ordinance, the Employment Agency Regulations, and the Code of Practice for Employment Agencies. Through a licensing regime, we conduct inspection, complaint investigation, and prosecution to regulate employment agencies, or EAs, in Hong Kong. According to the Employment Ordinance, anyone who wants to operate an EA, they must apply for a license from us. According to the law, we have to protect job seekers. If an EA successfully refers a job to a job seeker, then according to the law, the EA can at most charge the job seeker 10% of the first month's salary of that job seeker. The law empowers the Commissioner for Labour to issue a code of practice. Last May, we revised the code of practice. And we introduced more statutory requirements for EAs so as to step up protection for job seekers who need services from EAs. On inspection this year, for the first 9 months this year, we conducted 1,660 inspections. Our target is to conduct at least 2,000 inspections this year. For the first 9 months this year, we successfully prosecuted 4 EAs involving the following charges and crimes. For example, they failed to notify LD of changes in management or place of business within the statutory time frame, and furnishing to the Commissioner information which is known or reasonably ought to be known to be false or misleading. In respect of administrative sanctions this year, our department refused to renew the license of 1 EA because the sole director of the agency had been convicted under the Trade Descriptions Ordinance. As of this September in Hong Kong, we have 3,880 registered EAs in Hong Kong, and half of them offer placement services for foreign domestic helpers. There are also EAs that provide placement services for imported workers, and there is a significant increase in the number of these EAs. For the first 9 months this year, we issued 502 new EA licenses. Half of them, about 246 of them, are EAs that provide services for FDHs, and for the rest of them, about 250, they provide placement services for imported workers. Of course, an EA can provide placement services for both FDH and for imported workers. Our department will continue to stringently regulate EAs in Hong Kong through inspection, law enforcement, as well as publicity. We will ensure that the operation of the EAs in Hong Kong comply with the laws and the regulations, as well as the code of practice. Will also protect the rights and interests of job seekers. Thank you, Deputy Commissioner. 4 members have asked to speak. They will speak in the following sequence: Mr. Michael Luke, Mr. Chao Xiu-chung, Dr. Frankie An, and Ms. Lillian Kwok. 4 minutes for each member, including questions and answers. Mr. Michael Luke. Thank you. I'm asking this question on behalf of FDH. For the current health checks for FDH, could they be stepped up to make sure if the FDHs do not suffer from any illnesses such as cancer and heart diseases? Second question. EAs have been criticized of overcharging FDHs. How can the government step up regulation on EAs and at the same time let FDHs know of their legitimate rights and interests before they come to Hong Kong, so that they know how to report to the authority if the EAs violate the rules? Also, I see that there is a small number of prosecutions. If you look at the number of EAs we have and the number of complaints we have received, the number of successful prosecution is on the low side. Is it because of difficulties with law enforcement? Is it because of a lack of manpower? Is it because you have challenges with collecting evidence? What are the reasons behind? Deputy Commissioner, I thank Mr. Look for the questions. On the questions about FDH, according to our mechanism, EAs must enter into a service agreement with FDH. There is a standardized format for this kind of service agreements in the Code of Practice. And FDHs have to do health checks. And EAs have the responsibility to explain this to the FDHs when they sign the service agreement. The EAs have to learn what kind of employers it is for the FDHs. For example, will they have to take care of an elderly, a child? Then they will have to work with the FDH and arrange for the right kind of health check for the FDH. In this regard, we'll see whether we can step up dissemination of information for EAs as well as potential employers. Well, there is a dedicated website for FDH. There's also a dedicated portal for EAs. There's a lot of useful information on the websites. Moving forward, we will step up publicity. Employers can also look at the information published on the website for better understanding. Now, on the rights and interests of imported workers and FDH, we have talked about this on various occasions. Our existing mechanism is quite comprehensive. An imported worker, after coming to Hong Kong, he will have to attend a briefing held by the Labor Department. We also offer support services to imported workers. Our view is that for imported workers, a lot of them, they are concerned about the charges made by the employment agencies. Of course, employment agencies can only charge a commission that amounts to at most 10% of the first month's salary of the job seeker. We're seeing a rise in terms of the number of imported workers and therefore a rise in the number of complaints we receive as well. On complaints regarding overcharging of commission, our department will, of course, enforce the employment ordinance. We investigate each complaint we receive. Where there are cases involving intermediaries, we learn about the role of the intermediaries. For imported workers that come from the mainland, they have to get the approval from the relevant mainland authorities. And we may reach out to the relevant mainland authorities if we receive complaints or cases that concern imported workers from the mainland. There is a communication mechanism between us and the mainland authorities. The overarching principle is that we deal with each and every complaint we receive. We collect evidence and we conduct investigation. For most of the cases, we complete the investigation. For serious irregularities, of course, we will collect evidence, and with sufficient evidence, we will consult the Department of Justice before we decide whether to take out prosecution.
Mr. Chao Chiu-chung. Thank you, Chairman. After declared interest, the association that I belong to have obtained an exemptions from obtaining a license of employment agencies because it offered relevant services. It is said that some 260 complaints been received in the first 9 months of this year, and 23 of them have to do with imported workers. I'm concerned about commission. For these 23 cases relating to imported workers, what is the nature of the complaints? Does it involve overcharging of commission? Second, if a Hong Kong company has engaged a labor service company from the mainland, and if the mainland workers have paid intermediary or agency fees to the mainland intermediary, and then the Hong Kong company charge 10% of their first month's salary as commission. When this happens, it seems that the imported workers have to pay a lot in terms of agency fees and commissions, both to the intermediary and to the employer in Hong Kong. I think that even with the 10% requirement or restriction, that's still not very fair to mainland job seekers. Second, I'd like to ask about inspection. I wonder if the inspection against regular employers and employment agencies is different. I wonder if you will engage the same group of inspectors to look into whether the employers or employment agencies have taken out, say, insurance for the employees, have overcharged the employees with commission, so that we can fully utilize our resources more effectively. Thank you. Deputy Commissioner. Thank you, Mr. Chow, for the questions. On the fees to be paid by imported workers, well, the Labor Department's been looking into it, and we fully agree with what Mr. Chow said. We ask that the fees to be charged are in compliance with the mainland and Hong Kong laws. Second, the fees and commissions to be charged must be transparent. Third, the member made a very good point. Many different agencies and intermediaries may be involved in a recruitment process. We do think that we have to look into the issue. We try to improve things with employers, the employment agencies in Hong Kong, and the labor service companies on the mainland. So that we can further improve the entire process and make it more transparent. Now, regarding inspection, we have a dedicated team of inspectors to conduct inspection against employment agencies. They enforce the employment agency's regulations and the code of practice for employment agencies. Labor inspectors are not the ones responsible for enforcing them. When we receive complaints, we do have an internal referral mechanism. If labor-related complaints involve various areas, we may involve different teams. We share information internally within our own department. We do have an internal coordination mechanism. Regarding the 23 cases the member mentioned, I will see if my colleagues have anything to add. I believe that they have to do with commissions. Assistant Commissioner, please. Thank you. In the first 9 months, we received 23 complaints against imported workers, employment agents. There are 5 cases that have to do with operating without a license, and some of them have to do with violation of code of practice. As for 2 of the cases, they are not under purview. Thank you. Mr. Chow. A mainland employment agency may complete the entire visa application process for the mainland workers, and the Hong Kong EA may have nothing to do other than, say, arranging transport. But still, they charge the imported workers commission. I think that we should not just look at whether the commission charged exceed 10% of the first month's salary. We should look at the works the local EA has carried out for the worker. Deputy Commissioner, thank you. We'll look into whether the fee charged is reasonable. 10% is just the ceiling that a employment agency can charge. I understand the concern of the member, but for the fee level, I think that we should leave it to the market. There is competition among different employment agencies. We need to strike a balance. Thank you. Mr. Ngaman Yu, Deputy Chairman. Thank you, Chairman. I'd like to ask about EAs of FDH. The Deputy Commissioner just now said that they process different complaints under different divisions. For employers of FDH, they may have to go to different divisions to seek help. If they want to complain against the EA, they may have to go to Mongkok. If they want to complain against labor relations, they may have to go to your district offices. If they come across other types of disputes, they may have to go to the CNED, the Immigration Department. I hope that there will be an interdepartmental platform to handle complaints in relation to FDH. If not, I think that the Labor Department should establish an office to process complaints against foreign domestic helper. Should you not establish a one-stop platform for that? Second, you included many inspection figures in the paper. I wonder if you initiate any proactive patrol. Some employers of FDH are suspicious of syndicates encouraging FDH with chronic illnesses to come work in Hong Kong. So apart from inspections and patrols conducted to look into whether EA comply with the laws, have you conducted any interdepartmental investigation into suspicious cases? Deputy Commissioner, thank you. Over the years, we've been improving our service. We have a dedicated division for foreign domestic helper. We do also have a dedicated website for foreign domestic helper. It provides all types of information that an employers may want to know. We covered points to note for them and information for reference. And we also have a one-stop web portal for employment agency as well. So apart from a one-stop information portal, we also have complaint hotline to receive complaints and inquiries from employers, and we offer advice to callers. If employers want to seek conciliation service, if they want to file complaints on false trade descriptions, they may still need to go to dedicated divisions or different departments. There are things that we can process with a one-stop portal or platform, but there are also cases that need to be handled specifically by different divisions or departments. Regarding your question on investigation, maybe the Assistant Commissioner will elaborate. We leverage on our code of practice. We have amended it last year in response to concerns of employers. We often listen to the trade and stakeholders for their suggestions. Thank you. So apart from regular inspections, the Deputy Chairman would like to know if you conduct any proactive investigation against specific cases. Assistant Commissioner, please. Thank you. On proactive investigation or inspection, we do initiate them from time to time, and we adopt a risk-based approach. We look into whether there is any cases of social concern, if there is any complaints received against specific employment agencies before we launch any of such inspection. There are many EAs of FDH, and the users number is large. So EA of FDH have always been our target of inspection. The member asked about interdepartmental collaboration. We have a very effective mechanism of referrals. Say, for example, for job hopping cases, the Immigration Department refer them to us. And the Labor Department will look into whether there is any malpractice on the part of employment agencies. And if during our patrols we detect that in the course of their business the employment agencies make false declaration, we may refer the cases to the CNED for investigations under the Trade Description Ordinance.
Dr. Frankie Yan. I thank the administration for the response. Can one-stop services be offered to employers when they go to the Labor Department for complaints? I came across a case. The FHD concerned has questions about whether the contract has taken effect, and the FHD concerned went to Kwun Tong, to the office of the LRD. And the officer in Kwun Tong suspected that the case involves a syndicate, and the officer directed the FDH to Mongkok. What I'm asking is, can the Labor Department offer a one-stop service when listening to or investigating the complaints? If you ask an employer or a complainant to go to different offices of the Labor Department, it would be very troublesome for the employer. So when you first get the complaint, you should offer one-stop services, and after that, after you've received the complaint, you can make cross-departmental referral. I suggest that you have one office dedicated to listening to the complaint and recording the details of the complaint before referring the case to other divisions. Deputy Commissioner, we'll see how we can improve our services. At the first stage, perhaps we can collect the basic information first. Like the member said, we will think about it and design some kind of forms for our officers to deal with such inquiries, so that we can offer one-stop services in terms of collecting information. Well, you can explore making use of technology or AI to see if you can streamline the procedure. Please think about this. Ms. Lillian Kwok. Of course, it's great that if we have one-stop services, not just the Labor Department, but other government departments should consider rolling out one-stop services to provide greater convenience to the general public. I have several questions. I do hope that the government would improve its administrative procedures to offer greater support to the public. Just now, Chairman mentioned whether the Labor Department will make use of technology or AI. A lot of law firms nowadays make use of AI to respond to inquiry calls. I believe you have received a large number of cases, and you have made recordings for these phone calls. Would you consolidate the relevant data? We have started building our large language model, and there is a back-end system that's collecting the data. So will you have AI respond to inquiry calls from the public? If follow-up actions have to be taken, you can refer the person concerned to another department. Second, on the 3,880 employment agencies in Hong Kong, a lot of times one employment agency has a lot of registered addresses. Among the 3,880 EAs, have you conducted inspections on any of them to check how many registered addresses each EA has? Would it be possible that one EA contains 8 or even 10 registered addresses? I am concerned about this because you have a blacklist of EAs. And even if an EA stops its operation, it could switch to another premises or address to continue to run their businesses. Of course, you have rolled out better measures to prevent this, but I think the most effective measure would be to impose fines on EAs that breach the rules. Would you exempt employers from paying the administrative fee, or exempt them from paying for the air tickets for FDHs if there are any issues with the employment agencies? If it is the responsibility of the EA concerned, why would you pass on the responsibility to the employers? This way, you will be able to create deterrence and let EAs know that they have to be very careful with their operation, and at the same time, it can help reduce the burden of the government. Deputy Commissioner, I thank Ms. Kwok for the comments on applying AI. While I completely agree with Ms. Kwok, we are going to move towards this direction, and as the Chief Executive announced in his latest policy address, we are exploring how AI can support the delivery of government services. So moving forward, we will attach greater importance to the application of AI to improve our services. As for placement services offered by EAs to FDHs, one important requirement set out in the Code of Practice is that all EAs must enter into a service agreement with the job seekers, and they have to stick to the standard format for the service agreement. The Code of Practice sets out clearly how commission should be charged and how service fees should be refunded. We stress that EAs must be honest and responsible. They must provide true information to employers for reference. Otherwise, they would breach the Code of Practice and the relevant legislations. Ms. Lillian Kwok is concerned whether there are EAs that operate their businesses in multiple premises. I remember we had a relevant discussion last year. We took follow-up actions and we consolidated some data to learn about the situation. We reviewed our day-to-day law enforcement work and inspections, and we adopted a more targeted approach. I'll ask the Assistant Commissioner to supplement. I thank Ms. Kwok for the questions. For EAs that run their businesses in multiple premises, under the existing employment ordinance, there is no stipulation that an EA cannot run their businesses in more than one premises, and there is no restriction that multiple EAs cannot run their businesses in one single premises. Lillian Kwok's question is how we can effectively prevent people who breached the rules from setting up new businesses under the same on a different premises or with a different name. We adopt a stringent approval process. We check the operator's previous track records. We also look at the company's associates and check whether these associates have previously breached Part 12 of the Employment Ordinance. If they have previously breached the legislations, if they apply to run a new business, we may refuse their application. Ms. Kwok, I appreciate that you are willing to take follow-up actions on these cases. As I mentioned, there are 3,880 EAs. How many registered addresses are involved? Also, I think it's easy for a company to change its director. I can simply have my siblings be one of the directors of the company, so I can re-register for my company. What I'm asking is, can you cease the operation of the businesses? I understand that you have the requirements set in the code of practice, but we're seeing loopholes. Can we better plug the loopholes? We're seeing cases where EAs that have breached the rules continue to run their businesses using a different address. So as long as we spot an EA with questions, we can suspend their businesses. Same for the education sector. There could be an education institute that has previously breached the rules and continue to run their businesses using a different address. So what we can do is to stop the education institution continue to run its businesses. And I hope you would consider my suggestion of imposing fines. Employers have to take care of the accommodation and air tickets of the FDHs, even if the employment agency concerned has breached the rules. How come you're penalizing the employers, not the agencies? Deputy Commissioner, any reply? I thank Ms. Kwok for the suggestions. We will seriously think about the suggestions. So we've wrapped up this item. I hope the Labor Department have heard members' views and that it will continue to step up regulation of employment agencies. Next agenda item, any other business. This panel meeting is the last regular meeting of the 2025 legislative session. On the 22nd of October, at the council meeting, I will submit a report. I'll report on the work of this panel within this year. I'm grateful for members and deputy chair for their active participation and support in the work of this panel. Lastly, representatives from the Labor Department have a few words to say on behalf of the government. Deputy Commissioner, this is a rare opportunity. It is totally a coincidence. This is the last meeting of the panel on manpower. So this is a coincidence that I have the chance to meet with all of you. I'd like to take this opportunity to thank you and thank the panel for the work over the past 4 years. We have held many meetings over the past 4 years. We have covered a lot of topics which have to do with labor, For example, we talked about labor relations, we talked about OSH as well as the legitimate rights and interests of workers. Members have offered many valuable and constructive suggestions. As mentioned, every time after the meeting, we think about members' suggestions and explore how we could further improve our services and make better arrangements. I thank the panel for supporting the legislative proposals made by the government. A lot of the funding proposals and staffing proposals were supported by members, and we managed to take forward our work smoothly. I want to thank Deputy Chair Dr. Frankie An and the former Chair Mr. Michael Look. They chaired the meetings in a very effective manner, and they helped ensure that all the meetings went very smoothly. I hope that we will continue to work closely with this panel in future, and that together we will take forward the policies on welfare and manpower. Thank you, Deputy Commissioner. I also thank the LWB and the Labor Department for actively responding to members' concerns. Let's work hard together to promote policies to improve the protection for our workers and to ensure that there are good human resources policy. Thank you. There being no further matters, this is the end of today's meeting. Thank you.